Hey everybody, this is an article that's titled Franz Neumann. It's by an Alfons Söllner. Originally published in Kritische Justiz, I don't know, 4 in 1980, translated by David J. Parent. Let me do some quick. According to Wikipedia, Franz Neumann lived from 1900 to 1954 and was a German political activist, Western Marxist theorist, and labor lawyer who became a political scientist in exile and is best known for his theoretical analyses of Nazism. Franz Neumann studied in Germany and the United Kingdom and spent the last phase of his career in the United States, where he worked for the Office of Strategic Services from 1943 to 1945. During the Second World War, Neumann spied for the Soviet Union under the codename Ruff, together with Ernst Fraenkel and Arnold Bergstraesser. Neumann is considered among the founders of modern political science in the Federal Republic of Germany. According to Wikipedia, Alfons Söllner was born in 1947. Alfons Söllner is a German political scientist and university professor. Söllner studied political science, philosophy, sociology, and German studies in Regensburg and Munich from 1967 to 1973. In 1977, Alfons Söllner received his doctorate from Kurt Sontheimer. From 1979 to 1984, Alfons Söllner worked at the Free University of Berlin. In 1986, Alfons Söllner qualified as professor at the Otto Suhr Institute there. Alfons Söllner held professorships in Hamburg and Bremen and was a fellow at the Wissenschaftscollege in Berlin. From 1994 to 2012, Alfons Söllner was professor of political theory and the history of ideas at the Chemnitz University of Technology, and has been a liaison lecturer for the Fulbright Commission since 2003. With Alfons Söllner's study, German political scientist in exile, Alfons Söllner made a significant contribution to the history of political science. All right. Franz Neumann would have been 80 years old on May 23, 1980. It is no accident that this German-American lawyer and political scientist, killed in an auto wreck in 1954, has only very recently been receiving the attention his work deserves. Footnote: Franz Neumann, Behemoth, Structure and Praxis des Nationalsozialismus, 1933 to 1944, published with Frankfurt, 1977. Wirtschaft, Staat, Demokratie, Aufsätze, 1930 to 1954, published in 1978. Die Herrschaft des Gesetzes, published in 1980. Previously only Demokratischer und autoritärer Staat, published in 1967, had appeared. End footnote. A staunch opponent of National Socialism from the very beginning, Franz Neumann personally tackled the question of guilt in an almost self-tormenting manner. Quote, Why do I love this country so much, yet also despise it? End quote. Franz Neumann wrote in a 1954 letter to Helga Pross. According to Wikipedia, Helga Prost was a German sociologist. And back to the text. And Franz Neumann answered, quote, "Perhaps it is a deep-seated guilt feeling. How often after 1933 I have pondered the question of what my responsibility for National Socialism really was. For I believe in collective guilt, but then I cannot exclude myself from it, ... We opponents of reaction were all too cowardly. We were all compromised. I saw with my own eyes how deceitful the German Social Democratic Party was in the months from July 1932 to May 1933, and not only then, and I said nothing. I saw how cowardly the union bosses were, and I continued serving them. I saw how two-faced the intellectuals were, and I remained silent. Of course, I can justify this rationally in terms of the united front against National Socialism, but actually fear of isolation was a factor, ... So I collaborated in selling out the ideas of the so-called German left. Certainly, my contribution was slight, and a politician will judge my behavior ironically. But can the decline of the German Social Democratic Party and the rise of National Socialism be seen just as a political problem? Didn't moral decisions have to be made? I made them too late and still not radical enough," end quote. Franz Neumann. A lack of future perspectives is also the result of a short memory. Precisely from the standpoint of the future, we need not only criticism that alters consciousness, but criticism that redeems as well. We need to remember. New section, Labor Law and Economic Democracy, The Practicing Jurist, 1918 to 1933. Neumann was the son of a Jewish merchant from Katowice. He studied law in Breslau, Rostock, and Frankfurt from 1918 on. Contact with the council movement in Leipzig, where Franz Neumann took part in the struggles of revolutionary workers and soldiers, turned Franz Neumann's interest very early to the historical conflict between capital and labor. In the struggle between social democratic and communist strategies that were decisive for the early Weimar Republic, Franz Neumann sided with the reformists. This identifies the historical and political conditions that led Neumann to focus on labor law and economic democracy as his primary interests. Franz Neumann's dissertation, written in 1923 under the neo-Kantian Max Ernst Mayer, sought to bridge the gap between the is and the ought in terms of legal sociology. Neumann's character was shaped in the years between 1923 and 1927, when, besides training as a junior lawyer and teaching at the Frankfurt Labor Academy, he worked as a personal assistant to Hugo Zinsheimer. Through the person of this spiritual father of Weimar labor law, he became acquainted with the precarious position of the Jewish socialist intelligentsia in Weimar academic life even before National Socialist terror became widespread. According to Wikipedia, Hugo Zinsheimer lived from 1875 to 1945 and was a German legal scholar and contributed to the writing of the Weimar Constitution. Hugo Zinsheimer was a leading proponent of the concept of social law. Through the person of this spiritual father of Weimar labor law, Neumann became acquainted with the precarious position of the Jewish socialist intelligentsia in Weimar academic life even before National Socialist terror became widespread. Neumann reports that in the early 1920s, Neumann had to help defend the recently appointed professor of labor law against anti-Semitic attacks by nationalist students. After 1928, Neumann went into private practice in Berlin, where he shared a law office with Ernst Fraenkel, or Fraenkel, F-R-A-E-N-K-E-L. According to Wikipedia, Ernst Fraenkel lived from 1898 to 1975. Ernst Fraenkel was a German-American lawyer and political scientist. Ernst Fraenkel is considered one of the, quote, fathers of modern political science in the Federal Republic of Germany and West Berlin. Fraenkel wrote in particular about four political systems: the Weimar Republic, the Nazi state, the United States, and the Federal Republic of Germany. Ernst Fraenkel's collected writings have been published as a complete edition in seven volumes since 1999. Quote, the life's work of Ernst Fraenkel is characterized by his development from socialism to pluralism, end quote. During the Weimar Republic, Fraenkel worked as a lawyer for the socialist workers' movement and published a large number of articles mainly on labor law issues. Persecuted by the National Socialists as a Jew and involved in the resistance, Ernst Fraenkel emigrated to the United States, where he completed the dual state, his interpretation of the Nazi state. The dual state was published in German in 1974 under the title Der Doppelstaat, and is now considered a classic. Fraenkel developed the central idea of neo-pluralism and was one of the founders of West German democratic theory. Ernst Fraenkel used his studies of the United States to compare Germany with Western democracies and to analytically and normatively substantiate his own ideas on democratic theory. From 1963, Fraenkel served as the first director of the John F. Kennedy Institute for North American Studies at the Free University of Berlin. Back to the text. Neumann's productivity in private practice is documented by an abundance of works on legal theory. Or I guess, Neumann's productivity in this field is documented by an abundance of works on legal theory. Franz Neumann wrote about technical legal problems, but from within the perspective of a comprehensive political strategy focusing on unions and the state. The strategy was reformist insofar as it believed that socialism could be developed by the imminent transformations of capitalism through legal and political means. Although less skeptical than Otto Kahn Freund, Neumann had no doubts that the juridical decisions of the National Labor Court, influenced by the ideals of communitarian workplace organization, Betriebsgemeinschaften, would, once institutionalized, be far from meeting the workers' original expectations. Here he saw the ambivalence of legalizing class struggles, i.e. of delegating the resolution of conflicts to judges who are anything but pro-socialist. Otto Kahn Freund lived from 1900 to 1979 and was a scholar of labor law and comparative law. Sir Otto Kahn Freund was a professor of at the London School of Economics and the University of Oxford. Back to the text. Along with a respect for formal legal rationality, Neumann's intensive concern for the newly passed labor laws instilled in Neumann an awareness of its possible misuse within monopoly capitalism, which seemed all the more likely through the weakening of the parliamentary legislature. Neumann diagnosed the vociferous demands of the free law movement and the attempts to establish a Supreme Court to review the constitutionality of laws as promoters of the decline of formal legal rationality. Neumann recognized very clearly the political and social meaning contained in such changes of legal theory and practice, the release of the socially reactionary judges from the control of laws that sought to develop legal equality into social equality, and thus the suspension of the primacy of the legislature over the judiciary, unquestionable for a state based on the rule of law. Already in the Weimar Republic, not only Neumann's practice, but his theory as well is clearly informed by extrajudicial, political, and sociological ideas. Neumann follows the example of Zinsheimer and the Austro-Marxist Karl Renner. Nonetheless, even after the worldwide economic crisis, and unlike Otto Kirchheimer, in his sociological studies of constitutionalism, Neumann did not recognize the systematic nature of the erosion of the Weimar state and juridical apparatus that had occurred since Brüning's resumption of office. Otto Kirchheimer was a socialist-influenced German-American constitutional lawyer and political scientist who worked in Germany, France, and the United States. Otto Kirchheimer is considered one of the most important German political and constitutional theorists. Back to the text. Neumann still did not recognize the systematic nature of the erosion of the Weimar state and juridical apparatus that had occurred since Brüning's resumption of office. This is evident from the fact that from 1929, Neumann concentrated on questions of economic democracy instead of the crisis, i.e., at a point when the social and political foundation of the 1928 trade union program had been already destroyed. And it is also evident from the way Neumann does this. His works on economic democracy insist on the constitutional and legal dogmas of a democratization of the economy, in which the unions on a par with the entrepreneurs are to play a decisive organizational role. This specific historical situation, about which we know more today, can be observed in Neumann's writings on constitutional theory between 1930 and 1933. Like most of his contemporaries, Neumann did not recognize that already under the Brüning government, a workers' movement that submitted itself to the legality of a constitution already eroded by unconstitutional measures was condemned to failure. For even Brüning, whom the Social Democrats believed to be a buttress against Hitler, consciously rendered the Weimar Reichsconstitution ineffective, even if it did not change it. According to Wikipedia, the constitution of the German Reich, usually known as the Weimar Constitution, was the constitution that governed Germany during the Weimar Republic era of 1919 to 1933. The constitution declared Germany to be a democratic parliamentary republic with a legislature elected under proportional representation. Universal suffrage was established with a minimum voting age of 20. The constitution technically remained in effect throughout the Nazi era, from 1913 to 1945, as well as during the Allied occupation of Germany from 1945 to 1949. Though practically it had been repealed by the Enabling Act of 1933, and thus its various provisions and protections went unenforced for the duration of Nazi rule. And after World War II, the power of the Allied Control Council and four occupying powers once again stood above the provisions of the Constitution. The Constitution's title was the same as the Constitution of the German Empire that preceded it. The German state's official name was German Reich, German Deutsches Reich, until the adoption of the basic law of the Federal Republic of Germany and the Constitution of the German Democratic Republic in 1949. Back to the text. A paradox emerges. Compared to the demands of the rematerialization of formal legal rationality, which Carl Schmitt and his anti-democratic supporters advocated, the jurists of the workers' movement proved to be traditional legal positivists. They took the formalism of the bourgeois constitutional system more seriously than its bourgeois reformers. According to Wikipedia, legal positivism means, in jurisprudence and legal philosophy, legal positivism is the theory that the existence of the law and the law's content depends on social facts such as acts of legislation, judicial decisions, and customs rather than on morality. This contrasts with natural law theory, which holds that law is necessarily connected to morality in such a way that any law that contradicts morality lacks legal validity. Thomas Hobbes defined the law as the command of the sovereign. This idea was elaborated in the 18th and 19th centuries by legal philosophers such as Jeremy Bentham and John Austin, who argued that a law is valid because it is intrinsically moral or just, not because it is intrinsically moral or just, but because it comes from the sovereign, is generally observed by the people, and is backed up by sanctions. Hans Kelsen developed legal positivism further by separating law not only from morality, as the early positivists did, but also from empirical facts, introducing the concept of a norm as a, quote, ought, end quote, statement, as distinct from factual, quote, is, end quote, statements. In Kelsen's view, the validity of a legal norm derives from a higher norm, creating a hierarchy that ultimately rests on a, quote, basic norm, end quote. The basic norm, not the sovereign, is the ultimate source of legal authority. In addition to Kelsen, other prominent legal positivists of the 20th century include H.L.A. Hart and Joseph Ratz. Back to the text. In politics, they also proved to be legalistic, in the sense not only of fidelity to written law, but an excessive reliance on the inviolability of a constitutional system that in the period of economic crisis no longer had any real guarantees behind it. In this regard, Neumann and his colleagues shared the general fate of reformism at the end of the Weimar Republic. As Neumann self-critically noted shortly afterwards, this fate was, quote, as much inevitable as our own doing, end quote. New section. From Liberalism to Fascism, The Legal Theorist, 1933 to 1942. As late as 1932, Neumann had been appointed legal representative of the Social Democratic Party, and in this function he fought against restrictions on freedom of the press. After the occupation of union buildings by the SA, Neumann had to escape from Germany at the beginning of May 1933. The first stop of his emigration route was London, where through the efforts of Harold Laski, he received a scholarship to the London School of Economics. According to Wikipedia, Harold Laski lived from 1893 to 1950. Harold Laski was an English political theorist and economist. Harold Laski was active in politics and served as the chairman of the British Labour Party from 1945 to 1946 and was a professor at the London School of Economics from 1926 to 1950. Harold Laski first promoted pluralism by emphasizing the importance of local voluntary communities such as trade unions. After 1930, Laski began to emphasize the need for a workers' revolution, which he hinted might be violent. Laski's position angered labor leaders who promised a non-violent democratic transformation. Harold Laski's position on democracy threatening violence came under further attack from Prime Minister Winston Churchill in the 1945 general election, and the Labour Party had to disavow Laski, its own chairman. Harold Laski was one of Britain's most influential intellectual spokesmen for Marxism in the interwar years. Citation needed. In particular, Harold Laski's teaching greatly inspired students, some of whom later became leaders of the newly independent nations in Asia and Africa. Harold Laski was perhaps the most prominent intellectual in the Labour Party, especially for those on the hard left who shared his trust and hope in Joseph Stalin's Soviet Union. However, Harold Laski was distrusted by the moderate Labour politicians who were in charge citation needed, such as Prime Minister Clement Attlee, and was never given a major government position or a peerage. Born to a Jewish family, Harold Lasky was also a supporter of Zionism and supported the creation of a Jewish state. Back to the text. Neumann's attention at first still focused on German developments, meaning following Nazi policy, self-critique of reformism, and support of internal resistance. Footnote, see his State and Labor in Germany in the Contemporary Review, published in 1934. End footnote. But Neumann soon turned to the genuine options that were still available to him in the emigration, after realizing the uselessness of continental European jurisprudence for English case law. Neumann turned to theoretical work and research. It is symptomatic for the history of German jurisprudence after 1933 that its critical future development had to take place outside the country, and that this course led out of juristic immanence to a political and sociological thematization of law, the law. The London School of Economics, where an interdisciplinary and comparative approach was dominant, proved to be an ideal place to speed up this process. Here, under the guidance of Harold Lasky and Karl Mannheim, Neumann was transformed from a jurist to a political and social scientist, without, however, losing sight of the law. Instead, the law became the nucleus around which Franz Neumann attempted to synthesize the significant developments of more recent history. The book, The Governance of the Rule of Law, written in 1936 and translated into German just recently, testifies to this. I don't see anything like specifically for this piece on the internet. Back to the text. As Neumann himself points out, it is a theoretical extrapolation of the Weimar experience into the legal history of bourgeois society, from liberalism to fascism, mediated through Karl Renner's exemplary study and Karl Mannheim's sociology of knowledge. Neumann places himself under the aegis of two theorists whose work, although already ranked among the classics of social science, had hardly found application to the most recent development of law, Karl Marx and Max Weber. Neumann takes from them the distrust of methodically isolating legal concepts and from legal practices, and the search for a structural social context in light of which both the theory and practice of law must be understood. This historically and theoretically ambitious approach is Neumann's contribution to legal theory. The type of legal science that Neumann worked out in the 1930s can be characterized in terms of the relation Neumann established between legal doctrine, the philosophy, and sociology of law. It seems like Hans Kelson's legal theory is best summarized in the book Pure Theory of Law. Pure Theory of Law is a book by jurist and legal theorist Hans Kelsen, first published in German in 1934 as Reine Rechtslehre, and in 1960 in a much revised and expanded edition. The latter was translated into English in 1967 as Pure Theory of Law. The title is the name of his general theory of law, Reine Rechtslehre. Hans Kelsen began to formulate his theory as early as 1913 as a, quote, pure form of, quote, legal science, end quote, devoid of any moral or political or at a general level sociological considerations. Its main themes include the concept of, quote, norms, end quote, as the fundamental building blocks of law and hierarchical relations of empowerment among them, including the idea of a, quote, basic norm, end quote, providing any ultimate theoretical basis of empowerment, the ideas of, quote, validity and, quote, efficacy, end quote, of norms, legal, quote, normativity, complete separation from morality, and ideas relating to legal positivism and international law. The impact of the book has been enduring and widespread, and is considered one of the seminal works of legal philosophy of the 20th century. Back to the text. In opposition to Hans Kelsen's theory of law and to the materialization of law in Carl Schmitt's ontologized theory of sovereignty, Neumann arrives at a standpoint that gives normative jurisprudence its due, while assigning to the sociology of law an even more comprehensive task than the philosophy of law. The systematic error of this approach is twofold: Weber's sociological theory of state sovereignty, and a juristically formulated but historically and sociologically informed typology of basic rights. This twofold methodology, in which Neumann's neo-Kantianism reappears, is applied first to the history of ideas and to theories of bourgeois constitutional government. This development is reconstructed in light of the contradiction between basic rights as freedom and state sovereignty, and Neumann sees its consequence to be the thoroughgoing positivization of natural law. Second, Neumann reconstructs an ideal type of the bourgeois legislative state, whose purest historical realization is seen in the classical parliamentarism of English liberalism. The juristic and sociological elaboration of this ideal type utilizes a functionalist and systematic perspective. From a systematic viewpoint, in bourgeois society, a system of law develops whose precarious, semi-autonomous character is anchored in the status of basic rights and in the dominant qualities of the law: generality, determinateness, non-retroactivity, the binding force of the law and the judges. The functional significance of this system of law is threefold. Economically, it makes economic processes calculable. Politically, it simultaneously secures and conceals the hegemony of the bourgeoisie. Culturally, it guarantees the individual a minimum of legal security and justice. The ideal type played a double role in the historical investigations of Neumann carried on in the 1930s. It was a point of reference both for research technique and, normatively, the theoretical and ideal expression of a rationality, both inherent in and made impossible by competitive bourgeois society. In Neumann's analysis, the German state of the rule of law, Reichsstaat, and English parliamentarism were presented as two variants of this rationality. The development Neumann underwent during his London exile from a reformist practitioner of the law to a materialist theorist of the law, not for legal theory alone, is significant not for legal theory alone. This development indicates how jurisprudence could become the center of a theory of bourgeois reason. This was also the theoretical reason that made it possible for Neumann to become a co-worker of Max Horkheimer's Institute for Social Research in 1937. In the work of the Institute, Marxist theory formation attained its most advanced state, characterized by a program of social research differentiated according to disciplines and with interdisciplinary feedback. Along with Otto Kirchheimer, Neumann was responsible for research in the law and the state. Their articles in the Zeitschrift für Sozialforschung show far better than more recent abstract Marxist derivations of state and law that an acceptable materialist science of the law can only be developed in close contact with the scattered material of legal history. Neumann organized these materials from German, English, and French legal history into an analytical framework encompassing liberalism, mass democracy, and fascism. Neumann's thesis was that under the pressure of a developing economic and political monopoly, the formal rationality of law is transformed, materialized, and ultimately destroyed. He names statutory jurisprudence, the free law movement, emergency measures, and the revival of natural law to be among some indicators of this process. Neumann's main efforts between 1937 and 1942 no longer concerned problems in theory and study of law in the strict sense, but German National Socialism as a whole. Behemoth, first published in 1942, which soon brought him international fame, is a comprehensive analysis of the political, economic, social, and ideological structure of Hitler's Germany. I'm going to read the Wikipedia for Behemoth real quick. Behemoth, the structure and practice of National Socialism. Behemoth, the structure and practice of National Socialism, 1933 to 44, is a book by the German lawyer and political scientist Franz Leopold Neumann. It was written from 1941 to 44 during Neumann's exile in the United States and appeared for the first time in 1942, then in an expanded edition in 1944. Contents. The title is a reference to Thomas Hobbes' book Behemoth from 1668 and the biblical monster of the same name. Although Nazi Germany appeared as an authoritarian and strong state, Neumann did not compare Nazi Germany with the monster Leviathan, also used by Hobbes. Instead, Neumann equated Nazi Germany with Behemoth, which to Hobbes had represented a state of lawlessness in society, the state of nature. In a complex analysis, Neumann tried to show that behind the authoritarian and autocratic facade of the Nazi regime, there was ultimately nothing but unbridled terror, egotism, and arbitrariness on the part of certain social groups. An example of this was the Aryanization, confiscation, of Jewish property, which had mostly served the interests of large capitalist companies such as Mannesmann or Thyssen. Reception. Despite a sometimes mixed reception when first published, e.g., quote, the author is not always convincing, end quote, says Dwight E. Lee. Quote, the facts Neumann gives not only represent the most detailed analysis of National Socialism, but are undistorted, true, complete, and reliable, but his interpretation of these facts is open to the most serious doubt and criticism, end quote. The book was generally well received, e.g., quote, one of the most important books on Nazi Germany that has appeared in recent years, end quote. That's from Koppel S. Pinson. Quote, this is not just another book about Nazi Germany. It is the most significant attempt yet made at scholarly and painstaking analysis, based almost exclusively upon German sources, of the background, working principles, and practices, and present state of National Socialist Germany, end quote. The book is now often seen as a, quote, standard work on the subject of National Socialism, end quote. That's according to Duncan Kelly. Where am I? Back to the text. This work is one of the few theoretically and empirically comprehensive studies of a modern social order. Here we can only mention that at first a paradigm shift occurs in it from a legal to a sociological analysis of domination. Second, Neumann claims that in the economy of National Socialism, elements of monopoly capitalism predominate over those of planned capitalism, which implies a particular reformation of the Marxian critique of political economy. And third, He presents this social structure as the formation of anarchically competing ruling elites. Recent detailed historical analysis continues to document the adequacy of Neumann's approach. Concerning the development of law, in Behemoth, Neumann came to finding that National Socialism revealed with utmost consistency what the historical logic of the Weimar crisis has been leading to: the destruction of democratic achievements and the reintegration of the working class into imperialist capitalism. Accordingly, Neumann saw the most grievous legal changes to have occurred in the fields of labor law, political penal law, and democratic and individual rights. This amounted to the replacement of legal rationality by a terror, which sought to hide itself behind a populist ideology of natural law. By comparison, civil law, which is a class law after all, seemed like an idyllically remote image of a legally informed rationality. New section: Democracy and Freedom. The Political Scientist, 1942 to 1954. In 1942, Franz Neumann left the Institute for Social Research and, together with Kerkheimer, Herbert Marcuse, and Arcadius Gerland, entered the service of the U.S. State Department. Since National Socialism did not seem defeatable from within, the possibility of an effective anti-fascist struggle was offered by the alliance with the only power still undamaged by Nazism. In the Office of Strategic Services, where he had worked from 1945 on as director of the German Department of the Research and Analysis Branch, Neumann produced compendious studies on various problems such as war crimes and denazification, the function of the military government and the nature of the future German state, and the social power relations after the war. Neumann's development in this creative period is influenced by his activities as a practical policy advisor. Once again, Neumann's biography reveals more the byways than the highways of German history. Both the transformation of a legal theorist into a political scientist and the political reference point for this are untypical. All of Neumann's works published after 1947 focus on the reconstruction of a stable democracy in Germany. It is characteristic of his analyses of Germany that they rightly differ from the moralism of the, quote, 0 hour, end quote. As much as Neumann stressed the roots of National Socialism and national psychology, Neumann never forgot the structural, i.e. the economic, social, and political causes for the rise of the German evil. And in view of internal German and international constellations, these were well on the road to survival. Neumann held the thesis, unpopular among Americans, that democracy in Germany had scarcely a chance, without a radical transformation of the monopoly state capitalist economy and the dismissal of reactionary officials and judges. These are steps that went well beyond demilitarization and a denazification, soon to become obsolete. Resuming his past role as critic of justice, Neumann warned especially against the, quote, fetishism of the Constitution, end quote, among the fathers of the Constitution. Besides the general illusion of the legalization of conflict situations, to which Weimar reformism had also succumbed, he understood by this the neoliberalism which was experiencing a resurgence in America and Germany in reaction to fascism. When the new German constitution reacted to the Weimar experiences by strengthening liberal rights while abridging basic social rights, by stressing federalism, by strengthening the position of the chancellor and the government, and by introducing the constitutional court, This suggested that the weaknesses of Weimar democracy had been produced by too much social democracy, excessive parliamentary sovereignty, centralism, and the excessive politicization of the citizens. In Neumann's eyes, this was nothing but a distortion of the Weimar crisis. The political imperatives, which Neumann, for the most part in vain, stressed for the American occupation policy, have their theoretical corollary in his scientific works after 1950. Neumann had been appointed visiting professor at Cornell University in 1948, and in 1950 he became professor of public law and government there. He wrote a number of political treatises in this function, centering on the problem of democracy, its conditions and possibilities in advanced capitalist society. He taught with considerable success at Columbia University and had considerable influence on the establishment of political sciences in Germany, especially at the Free University of Berlin. The themes Neumann concentrated on were mainly grouped into two fields. On the one hand, power domination in the political system, on the other, political philosophy, its history and present significance. The form in which Neumann related political analysis of real processes to political philosophy envisaged a political science that succumbed neither to the positivism of American political science nor to the neo-normativism of totalitarian theory. Neumann's aim was to conceive a, quote, real theory of politics, end quote, within the framework of a carefully formulated social theory of late capitalism. The implications of this position for jurisprudence are concretely presented in the long treatise on the concept of political freedom. Yeah, it looks like an essay. I don't know. The dimension of juristic freedom, which is treated extensively as assigned an indispensable, though only a negative role in modern society. While the accent is placed more on the cognitive element and even more on the element of the will intrinsic to freedom. The active and creative perception of freedom first makes democracy capable of survival. Its increasing hindrance through the alienation of citizens from politics, through the transformation of culture into propaganda, through the restrictive treatment of the basic rights of political opponents, create dangers that make a real democracy increasingly difficult to realize. Neumann saw these dangers to grow perilously not only in totalitarian societies, but in Western societies as well. This was tangible, for instance, in the loyalty program of the McCarthy era. It is significant from a theoretical standpoint that even in his late essays and despite a shift of interest, Neumann remained faithful to the social theoretical intentions of the materialist phase. They are, however, formulated more cautiously and do not go beyond a programmatic stage. What one will not find in his work are the typical abstractions of pluralist theory, detached from the structure of society and soon adopted by political science of the 1950s and 1960s as the official legitimation science of the West German state. It is rather interesting that in his last published work, Neumann adopted socio-psychological methods in order to point out the dangerous connections of anxiety and politics, which he saw to be threateningly effective in both East and West. This may have been a sign of a development that would have made the political scientist into a social psychologist, a step that Neumann's untimely death did not allow. New section. On the actuality of Franz Neumann. The theory and practice of the West German Rechtsstaat have come into commotion again since the early 1970s. After the insecurity caused by the student movement and confronted with the economically compelled stopping of reforms, a conservative reactivation of public opinion began. Its spokesman sought to mobilize a reservoir of legitimation in order to initiate law and order types of corrections in the legal institutional structures of democracy. The consequences are considerable. Employment bans, Berufsverbote, on public employees affiliated with political parties without the corresponding outlawing of those parties. Disciplinary proceedings against state employees for disloyalty. The Bruckner case. The exhortation of loyalty statements, not to the Constitution, but to the state. Pestel versus the publisher of the Mescalero article. Amendments of the Penal Code to restrict freedom of opinion. Change of the penal trial systems and of trial legislation to restrict defendants' rights, especially the hastily enacted law prohibiting the defendant from contact with his attorney. The expansion of the state, i.e. the constitutional surveillance apparatus. They are all important, although they are not the only tendencies in recent developments. Such curtailments of the constitutional state, ironically passed as measures to defend and save it, are obviously anything but that. They are the first steps to its destruction. Franz Neumann is relevant today because the question raised by this development must be answered. It is not enough to rejoice in the, quote, carefree humor, end quote, that allows our literarily ambitious contemporaries to distance themselves from the political realities of the day. It would be equally wrong and hysterical to see the Federal Republic as drifting towards a new fascism. Rather, objective concern and theoretical seriousness are necessary as exactly the standards that can be acquired from a study of Neumann's biography and work, and which result from a theoretically informed consideration of the long-range historical tendencies of German constitutional government. Today, we can recognize that the flight of legal and political sciences into a revived doctrine of natural law, and thus into a value order transcending the limits of positive law, is a camouflage under which questionable tendencies had developed in a changed form since the Weimar Republic. The increased power of the Supreme Court, enabled by the federal constitution's court jurisdiction to review laws, and the encroachment of public and private bureaucracies upon preliminary liberties under the legitimation of, quote, contested democracy, end quote, to equate such tendencies in toto with the destruction of formal legal rationality under fascism, analyzed by Neumann, would, of course, be an exaggeration, but it must be asked what the illegitimation problems of contemporary parliamentarism, discerned by conservative and critical observers alike, mean in social and historical perspective. Such legitimation weaknesses seems to result from a general conflict between the constitutional rule of law and the imperatives of a social system transcending them, and their solution seems to require the mobilization of ideologies transcending the given legal order. A critical legal science will have to start at this point. A theoretically satisfactory solution can lie neither in systems theory nor in normative jurisprudence, nor in a critical one. Not in systems theory, because its, quote, value-free concept of legitimacy, end quote, methodically excludes the contradiction between right and might and elevates system preservation itself to apparently neutral, quote, supralegality, end quote. Kirchheimer. Not in normative jurisprudence, because this approach, instead of analyzing the social processes occurring below the plane of legality, tends to cover them up. It can be learned from Neumann that a critical legal science must distinguish among three levels and reintegrate them back together. The changing legal conceptions which define bourgeois legality, the theory and practice of the law subordinated to state sovereignty, and the economic social substratum, under whose imperatives conceptions and forms of law change. Such a theory, which in the last instance would have to be a historical social theory of legal rationality, does not yet exist. If this task is to be carried out, there is need for the active reappropriation of the tradition to which Franz Neumann, together with Ernst, Fraenkel, Otto Kirchheimer, and others belong. This tradition must no longer remain buried in the darkness of German legal history. Thanks for listening.